Today, I'd like to share some key lessons from the Philips versus Belkin litigation before the UPC. Okay, more particularly, the case concerns a standards essentiality patent, SEP, relating to the Qi wireless charging standard. Qi is a global dominant standard for wireless charging, enabling interoperable power transfer between chargers and devices. And it is implemented in millions of consumer products. So this makes the dispute particularly relevant, not only from a technological perspective, but also as an early and important test for how the UPC approaches SEP infringement, claim interpretation, and we'll see also liability and enforcement. So rather than walking through the case in detail, I will focus on the broader lessons that can be drawn for future SEP litigation before the UPC. But this case matters because it's one of the first times the UPC has dealt with a standard essentiality patent in an infringement context. The technology at issue, Qi wireless charging, is implemented at scale, which makes the court's approach particularly relevant for SEP holders and implementers alike. Beyond the technology, the decisions touch on several structural questions. How the UPC interprets patent claims, how far pan-European enforcement goes, whether individuals can be targeted by injunctions, and how strictly procedural orders are enforced. In that sense, this case functions as an early stress test for the UPC system. First, very briefly on the facts. Philips owns a European patent declared essential to the Qi wireless charging standard. Philips brought infringement proceedings before the Munich local division of the UPC against several companies in the Belkin group. The case concerns Qi-compliant wireless chargers marketed in multiple UPC states. Certain aspects, in particular issues of personal liability and enforcement, were reviewed by the Court of Appeal, while other findings, such as claim interpretation and infringement, remained at first instance. Importantly, there had already been parallel litigation in Germany before the Düsseldorf Regional Court, which becomes relevant later when we look at territorial effects and claim interpretation. So the central substantive issue in this case was claim interpretation. The claim at issue referred to a confirmation sent by the charger, which is the power transmitter, to the receiving device responsive to a request sent by the device for initiating a negotiation phase. Such negotiation phase is, for instance, to define charging parameters like power transfer and things like that. To refine the parameters for charging and power delivery from the power transfer to the receiving device. Okay. In this case, the confirmation sent by the charger determines whether the system enters a negotiation phase between the charger and the device. The dispute was about whether the confirmation sent by the charger must technically allow for both acceptance and rejections, which was linked to the way the claim was drafted with the feature indicative of an acceptance or rejection of the request. Belkin argued for a narrow reading. If a device can only ever accept and never reject, it falls outside of the scope of the claim. Philips argued the opposite. The claim covers systems that acknowledge the request, even if the response is always an acceptance. So this raised a broader question, which is particularly important for SEPs. How strictly should claims be construed when they are tied to a technical standard? The Munich local division rejected Belkin's narrow interpretation, in fact, it applied a classic but robust analysis linked to Article 69 of the EPC. Claims must be read in light of the description and drawings from the perspective of the skilled person. And a key point is that the patent description discloses an embodiment in which the charger always accepts the request to enter the negotiation phase. So, the court held that where multiple embodiments are presented as compliant, the claim should be read broadly enough to cover all of them. The court also emphasized in this particular case the technical purpose of the invention, which is enabling negotiation, not blocking it. This led the UPC to depart from the earlier Dusseldorf interpretation, relying on a narrow reading. However, in this case, for Germany, the prior judgment remained territorially effective, and the UPC decision was applying on the other territories. A second major and controversial aspect of the case concerned liability. Indeed, at first instance, the Munich local division did not limit injunctive relief to the Belkin companies. It also extended the injunctions to several individual directors. These directors were not found to be direct infringers. Instead, the court considered them to be intermediaries, such as defined under Article 63 UPCA, which is person providing services that enable the infringement and were in a position to prevent it. This immediately raised concerns, particularly about the risk of routinely targeting companies' directors in UPC infringement actions. So, on appeal, the court corrected what is considered to be a manifest legal error. It clarified that managing directors of an infringing company cannot automatically be treated as third parties or intermediaries simply because of their corporate function. Indeed, personal liability requires personal conduct going beyond corporate governance. At the same time, the Court of Appeal confirms the UPC's strong enforcement powers in relation to penalty payment. In fact, penalties are not only coercive, but are also punitive, and compliance after the deadline does not eliminate liability of the period of non-compliance. This sends a clear signal that procedural obligation before the UPC must be taken seriously. So, to conclude, this case gives us an early snapshot of how the UPC approaches SEP litigation. The court adopts a purposive and technically grounded approach to claim interpretation without treating SEPs as a special or defensive category. While the UPC showed an initial willingness to explore broad territories of liability, the Court of Appeal has already set important guardrails, particularly for individual defendants. Finally, the case makes clear that procedural orders, especially disclosure obligations, are not optional. Enforcement before the UPC has real bite. So, with that, I'm happy to take any question if you have.